And joining us now from outside the Supreme Court is former acting U.S. Solicitor General and MSNBC legal analyst Neil Katyal.
Hey, Neil, thanks so much for being with us. Main editorial in the Wall Street Journal has an overall theme I think that you and I would agree with. And I think most people would agree with it. Yes, an election is involved here, but much more is at stake for future presidents. Let me just read a little bit from this and get your insight on it. The burden on the justices will be finding a balance that recognizes the unique duties of the presidency while also holding presidents accountable for genuine law breaking. A president needs to be free to make controversial decisions without having to worry that he'll be prosecuted for them after he leaves office. But he shouldn't be free to commit crimes that are unrelated to the office. Then they talk about Nixon v. Fitzgerald and how the Supreme Court in that 82 case talked about how presidents should be protected. And, Neil, they talk about even to the outer perimeter of presidential duties. So help define that for us in your thinking, the outer perimeters of presidential actions and how the January 6 actions are still outside that perimeter.
Yeah, so the Supreme Court has said in Nixon versus Fitzgerald that presidents have immunity in civil lawsuits, or at least former presidents, for actions taken that are official acts. And that's done for a good reason. Anyone can file a civil lawsuit against anyone, and that's what the court said there. But the U.S. Supreme Court, Joe, has never, ever said anything like what Trump is saying here. When Trump claims absolute immunity, here's what that means in plain English. I, Donald Trump, can do anything I want, and the law, even the criminal law, can't touch me. And so, as was just shown in the Laura's package a moment ago, President Trump's lawyer said that it's fine for him to go and assassinate a political rival using Navy SEAL Team 6. That has never been the law. It's ridiculous. Trump says, oh, that means you won't have a presidency. No, you just need a president who doesn't commit crimes, which isn't a hard thing to do. We've had over 40 of them without any problem. Supreme Court's never said any of those 40 have absolute immunity. So this is actually a really easy case. I'm going to go walk in there and listen to it. Oral argument is supposed to be slated for an hour. I suspect it'll be a bit longer than that. But at the end of the day, the answer to this question is really, really painfully easy. And it's a little weird that we're all standing here waiting for the Supreme Court to decide a question that I think every serious constitutional scholar thinks the answer to is obvious. And by that, I mean not just every constitutional scholar, but even a prominent lawyer back in January 2021 who stood on the Senate floor and said, don't impeach President Trump. The remedy is to indict him after he leaves office. That person was Donald Trump's own lawyer in the impeachment proceedings.
Yeah, Neil, you've kind of anticipated my question, which is, this is not a nuanced argument that's being made by Trump's team here. They're saying absolute immunity. It's hard for an outside observer, you don't have to really be a legal scholar, just an outside observer to see how that would make any sense at all. So what is the best hope here for the team that's making that argument on behalf of Donald Trump?
I don't think that they have a chance in winning this case. I think what they have a chance of is getting a justice or two to write a dissent or a concurrence that'll slow down the writing of this opinion. And if they can slow it down enough, the hope is then Judge Chutkan, who's presiding over Donald Trump's January 6th trial, will be forced to schedule the trial after the election. And so the American people then will not get to hear all of the evidence against Donald Trump. And Liz Cheney had an important piece in the New York Times this week in which she said, look, Supreme Court, decide this thing fast because Jack Smith has used the grand jury to uncover all sorts of information against Donald Trump that I, Liz Cheney, and the other members of the January 6th committee did not have. And so the only way to get that in front of the American people is to have a trial before the election. So the stakes here aren't just about what the decision will say at the Supreme Court. The more important stakes are, when is the court going to say it?
So, Neil, I'm not even a simple country lawyer, and I don't know if this is possible, but given that time is of the essence here and this is about delays or trying to get this this trial happening speedily. Is it possible for the Supreme Court to say, OK, we need to deliberate this further, because it does look like there might be some divisions over this from some of the more conservative members, but in the meantime, Jack Smith's trial can go ahead, that we could, I don't know, could they lift the stay while they make the decision? Is that even possible?
It's such a smart question, and the answer to that is yes. The court did it at least once, to my knowledge, in 1942 in the trial of the Nazi saboteurs. They said the trial can go forward, a decision to come later, and the decision took some months. That was very much controversial on the court and outside the court. I don't think they want to repeat that process. So instead, the better thing to do is for the court to issue a quick decision. They've been able to do that in any number of cases, including Bush versus Gore. I was a junior lawyer on that. I remember the decision came out within maybe 24, 48 hours or so. So they can move fast when they want to. And I really, really hope the Supreme Court does. This has already been a long delay for briefing. They set 7 weeks for briefing, which was an extravagantly long time. This show needs to get on the road for the American people.